Thank you. Mr. Berry, Christopher Berry will be here for ADLF, and they will have 15 minutes for their presentation.
Good afternoon, Commissioners. My name is Carney Ann Nasser. I am Legislative Counsel for the Animal Legal Defense Fund, and I'm just going to take a couple of moments and then pass the baton over to Christopher Berry, a litigation attorney at ALDF, and Sara Wan, who, as you all, I'm sure, have had the opportunity to talk to, is here on behalf of ALDF and as a former chair of this commission. I just wanted to reiterate our position that this permit should not be granted, but if it is, that the commission is compelled to absolutely mandate the end of the captive breeding program at SeaWorld San Diego. And I would like to add one footnote. Just as a mother, I have a 5-year-old and I have an 18-month-old, and I have read the reports by medical doctors who specialize in early childhood development, and they have spoken at length and unequivocally about the fact that there's not only no educational value to taking our children to a facility like SeaWorld or to a circus like Ringling Brothers, it actually sends our message to our kids that other living beings, whether they are animals or humans, are merely here for our amusement. They're here for us to manipulate, control, and use for our own personal whims. And so at that, I would appeal to you as a parent and hand over the rest of our time to Christopher Berry and Sara Wan. Thank you.
Thank you for the opportunity to speak, Commissioners. My name is Christopher Berry, and I'm a staff attorney at the Animal Legal Defense Fund. And I'd like to spend a couple minutes of time just talking about your legal authority to act. And in particular, I'm very concerned about the staff report's refusal to account for the welfare of captive orcas as marine resource impacts under the Coastal Act. The report's refusal to consider captive orca welfare skews the balance of the entire analysis and its recommendation that you approve the permit with the very limited conditions. In particular, Section 30230 of the Public Resources Code requires that marine resources shall be maintained, enhanced, and, where feasible, restored. Unquestionably, this extends to animals, and moreover, there is no distinction in the statutory language between captive animals and animals in the wild. In fact, the Coastal Act and other environmental laws are regularly concerned with environmental and other impacts that happen in urban areas. The Commission itself, as the staff report points out, has in fact considered captive marine mammal welfare in the past in conjunction with other permits that it has granted, so there is precedent for the Commission to take that into account. While the best reading of Section 30230 is that it requires impacts on captive wildlife to be considered, at the very least, the staff report points out that the issue is open to interpretation. In other words, as commissioners, you at the very least have the discretion to consider the misery of captive orcas at SeaWorld and the future orcas that it will breed into existence if breeding is not limited by your possible approval of the permit. Now, the Commission not only is authorized to consider captive orca welfare in making its decision, but is uniquely situated to do so in light of the fact that the federal government isn't strongly regulating this, nor is the Fish and Wildlife regulations in the state of California. A couple hours ago, SeaWorld attorney David Watson stood up here and told you unequivocally that the Marine Mammal Protection Act expressly preempts this commission from imposing orca captivity standards. However, comments submitted by SeaWorld to the National Marine Fisheries Service in opposition to some proposed amendments to the Marine Mammal Protection Act in 2007, SeaWorld said, and I'm quoting verbatim here, the 1994 amendments to the Marine Mammal Protection Act unequivocally established that the National Marine Fisheries Service has no role in the care, maintenance, and general oversight of marine mammals once they leave the wild and enter into the United States. SeaWorld also said that NMFS would be overreaching and improperly extending its jurisdiction and authority by regulating orcas and other marine mammals once they are out of the wild. So it seems as though SeaWorld is willing to say whatever it needs to say when it's commercially expedient. Of course, the Animal Welfare Act does provide some minimal baseline standards, but it encourages explicitly state and local governments to go further and to do more, which is exactly what the Commission should do here. And of course, California's fish and wildlife regulations don't extend to orcas, leaving the ball in your court and putting you in a unique and special situation to take the welfare of captive orcas into account. Accordingly, we implore the Commission to consider the inherently inhumane nature of orca captivity in making its decision today, and SeaWorld must not be empowered to build more tanks that allow it to collect or breed more orcas who will fatally suffer and languish in captivity.
My name is Sara Wan, speaking on behalf of ALDF. The keeping of orcas in captivity for entertainment is cruel and totally unjustified, regardless of what SeaWorld says. It is inconsistent with current thinking and what we now know about what happens to these whales in captivity. I will not repeat what others have said about federal law or the absurdity of considering a tank to be habitat. I will focus on what I know best, the Coastal Act, and your ability to use it. Your staff has stated you cannot apply 30230 to animals in captivity as your standard of review, but frankly, that's false. Not only is the application of 30230 up to interpretation, which staff admits, and the Coastal Act itself states that 3009, that this division shall be liberally construed to accomplish its purposes and objectives. But you have applied it previously, and you cannot simply ignore that fact, particularly since that was the one instance that I am aware of where the issue of impacts to captive marine resources was an issue, and I've been at this at the Commission for over 30 years. Once you use 30230, and you did use it and apply it, I was on the Commission when you did, you cannot now say you do not have the right to use it. In fact, your staff goes on to use 30230 by making the claim that Special Condition 1 makes the project consistent with 30230, and relative to noise impacts, that the proposed project is in conformance with the marine resource protection policies of Chapter 3, i.e. 30230. It is completely up to you, the commissioners, to decide what makes the project consistent. If you don't agree with the staff's position about what constitutes consistency, you are free to substitute your judgment as to what does. In this instance, there is no way that Condition 1 makes this project consistent. Condition 1 gives SeaWorld free rein to use the new tank as a breeding tank because there are no marine mammal accredited reproductive guidelines. The only two professional accredited programs for cetacean facilities that exist, and they were here, and they didn't tell you they have those kinds of guidelines that the staff refers to, they don't have any reproductive guidelines specific for orcas. And what this means is that the condition that you have in front of you from your staff does not place any limitations on SeaWorld's ability to breed as many orcas as they wish. Your staff has said that the tank can hold up to 94 whales. So even if SeaWorld should agree to put an upper limit of 20 on it, which they indicated, on the number of whales, the new tank may hold, according to them, what amounts to twice as many orcas as there are, and it doesn't change anything relative to what we've been talking about. It would mean that even with that the current whales will not have any additional room. More importantly, whatever number they choose, that would only limit how many whales they could keep at any one time. They would be free to breed and ship and breed again. By the way, putting a cap on the number of whales that what they can breed just proves that the purpose of this tank is for breeding and for the public to view, which is what we've always suspected. It's not to benefit the whales. And contrary to your staff's contention that captive breeding lessens the need to capture orcas from the wild, the opposite is true. As long as breeding is a business that generates income by breeding and selling the orcas, there'll be a need for taking the whales from somewhere to avoid problems with inbreeding. Does the Virgin Pledge take care of that? Frankly, not. Okay? It doesn't deal with breeding at all. And regardless, this commission can put in place a condition that does have a meaningful impact. And that's what I said, okay? Okay. That does have a meaningful impact, while still allowing SeaWorld to continue exhibiting those whales already in their possession. The condition we asked for will result in the gradual phasing out of the use of orcas and actually providing more room to the existing orcas. By prohibiting breeding, that's what you do. We ask that SeaWorld only be permitted to hold or display the currently existing whales in its park. I won't go through their names. And that SeaWorld be prohibited from the captive breeding of orcas, either through mating or artificial insemination, including the collection of gametes. This is what would make the project consistent with 30230, and it is the only way that the new tank will ever give the orcas any more room. If SeaWorld says no to this, then it really does show their real intent. This condition would also send a statement that the Commission is in agreement with the current view that using these whales for entertainment purposes is not acceptable. The state of South Carolina has banned it. The nation of Canada has banned it. Assemblyman Bloom's bill is seeking to have California join South Carolina in banning this. And the nation of India has declared orcas to be non-human persons. How can this commission in good conscience turn its back on them? You have heard about how these beautiful, intelligent beings literally live their captive lives being tortured. You have the opportunity to be on the right side of history. I urge you not to turn away from your responsibility to give them the protections that legally can be provided to them, and you can give it to them legally. Unless this condition is substituted in its entirety for the current Condition 1, there will be no additional room for the existing orcas, and then the project should be denied. Thank you. And I'm going to hand this out. This is our substitute motion that we'd like you to substitute for Condition 1. Thank you.
Thank you. Okay, I'm